The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain some of the most important clauses for employers to include in employment contracts and independent contractor agreements. We'll discuss non-compete clauses, non-solicitation clauses, non-disparagement clauses, and trade secret/confidentiality clauses. They're basically one and the same. So first, let's start with non-compete clauses. A non-compete clause is the type of clause that most people are pretty familiar with, and this is a clause that says that after the termination of the employee's employment with the employer, that's a lot. It's a lot of the same word there. But after the termination of the employee's employment, they are not going to be able to engage in competitive business activity that competes with the employer's business. Now, in order to be enforceable, these have to be reasonably limited in time, geographic scope, and the type of business activity that's protected. So time, typically 2 to 5 years, have been upheld as a reasonable time period. It really depends on the circumstances and the importance of the employee's activity within the employer's organization. Geographic scope should be limited to the geographic locations that the employer actually does business or reasonably expects to do business in the near future. And finally, the business activity that's covered by the clause should be limited to activities that actually compete with the employer's business. If all of those things are limited properly, then non-compete clauses are enforceable. If it's an open-ended, poorly drafted general non-compete clause, then they tend to be unenforceable. So it's important, especially with non-compete clauses, to have an attorney draft or review the clause. Don't just try to draft this one yourself, because if you do, it's probably not going to be enforceable. A non-solicitation clause is kind of the little brother or sister to a non-compete clause. It is not required to be limited in geographic scope, but it's more limited in what it protects. Instead of all competition, it specifically prevents the terminated employee from reaching out to other employees, business partners, or customers and clients of the employer and soliciting them to try to get them to do business or join up with a third party or some other competitor of the employer. A non-disparagement clause prevents the employee from tarnishing the employer's reputation by saying bad things either verbally or online about the employer, either during or after the employee's employment. A trade secret or confidentiality clause basically applies during or after employment as well, and it deals with prevention of sharing business information such as marketing strategies, proprietary business systems, customer lists, and customer information. And if the employee violates any of these clauses, they can be liable for the employer's damages. You can also insert liquidated damages, which are a specific dollar amount that the employer can go after the terminated employee or independent contractor for. So if you have any questions, you can leave them in the comment section below this post at learn-about-law.com or below the video on our YouTube station. If you found this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud, and you'll be notified of our daily article and video posts. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.